Good afternoon and welcome to our webinar on the $2.67 billion Blue Cross Blue Shield Association class action lawsuit. And particularly today, what we're going to be focusing on is for employers who get a portion of this settlement, what are your fiduciary duties to as they apply to that settlement. I am joined by my partner, Dick MILLEREE, who is a litigator here at Miller Johnson. My name is Trip Vanderwall. I'm a member of our firm's Employee Benefits and Executive Compensation Group. Dick, you want to say hi to everyone?
Good afternoon, everybody, and happy Friday.
Yes, exactly. We thank you guys for joining us. We got some material, I think, hopefully you guys will find this interesting. We also did last week, Wednesday, I believe May 12, we published a client alert on the same issue that we'll be covering today. So if you want some more information, you can find that on our website. A couple of housekeeping items. I think it was on the initial screen, but if you have questions and answers, feel free to put those in through the question and answer box. And Dick will be monitoring those and we'll try to address those as we go through. Also, at some point after the webinar, the webinar will be posted on the firm's YouTube page, and I believe the slides will be available as well. With that, we'll get started. So, as most of you probably know, the Blue Cross Blue Shield Association, which is the nationwide association, was sued for antitrust violations or potential antitrust violations. We don't really need to cover the boringness of that, I don't think, but they have, to avoid future risk and costs of further litigation, they have potentially agreed to a settlement amount of $2.67 billion. And Dick, you were pointing out to me something and I thought that I hadn't even noticed about when the lawsuit was filed and where we are just 6 or 7 months later.
Right. This was a lawsuit that was filed in Alabama. The complaint itself, for those of you with any experience in litigation and have some knowledge of what a complaint usually looks like, this one is substantial. It is 137 pages long, containing nearly 550 separately pleaded allegations.
Yeah, that's pretty long, and
it was only filed on November 2nd of 2020.
So not that long ago for such a substantial settlement. Now, if you're feeling sorry for the lawyers for having to file such a substantial complaint, you don't have to, because out of this $2.67 billion, the proposed attorney's fees are just a minor $667 million, with another $100 million being used to administer the settlement and the distribution of the settlement, which leaves $1.9 billion in the settlement fund for eligible claimants. So we're going to cover here who are those eligible claimants, but keep in mind that you will likely get some type of communication from Blue Cross Blue Shield. I think primarily they have been in the form of a postcard, and I think they're sending them out throughout the nation at different times. It was about 2 weeks ago that both my wife and I got one, and my father and I got one. I think we got them all on the same day or a day apart. So in Michigan, you might have already received your blue postcard. But the eligible claimants, first focusing on employers. So they are employers who are sponsored a fully insured group health plan by an independent licensee of Blue Cross Blue Shield Association from the period of February 7, 2008, so a number of years ago, through October 16, 2020. It also includes employers that sponsored a self-funded plan that was administered by Blue Cross Blue Shield Association licensee, but the period is smaller. It only goes back to September 1, 2015, again through October 16, 2020. And because of these different time periods, the settlement fund is being allocated to, if you think of each, the fully insured pot and the self-funded being separate pots, the settlement fund is being allocated differently, and a substantial amount more is going to the fully insured fund. So out of the settlement, it looks like only 120 million is going to the self-funded pot, with the remainder going to the fully insured, which would both be employers and individuals who purchase individual policies. All eligible claimants also includes individuals enrolled in these group health plans, particularly employees that are enrolled in these group health plans, not their beneficiaries, so not an enrolled spouse or an enrolled children. It's the employee. They can make as we'll talk about soon, they can make an individual claim. And finally, if I have any individuals out there that purchase an individual insurance policy from the Blues, one of the Blues, you are also an eligible claimant. And again, that period, like the fully insured group health plan, is February 7 of 2008 through October 16 of 2020. Now, I want to spend a couple of minutes on governmental employers, and I've got my eye here on the number of participants in our webinar, and I'm going to see here when I get done with this slide if it ticks down. So if you are a state, county, municipality, an unincorporated association performing municipal functions, a Native American tribe, or do you think we have any representatives of the federal government on this website, Dick?
I'm not so sure.
That would be pretty cool. You are excluded from this settlement. So if you are representing one of those employers, you are more than welcome to stay on the webcast or the webinar, but it's not going to apply to you. So I will certainly not be offended if you sign off now. There are some governmental employers that are eligible for the settlement, though. Utility companies, and looking at the registration list, a big one was public school districts. So you folks are still going to be eligible. I will point out one thing that we'll talk about a little bit before, though. If you are a governmental employer or a church employer who are also eligible, you are not subject to ERISA. So, again, you guys are more than welcome to stay on this webinar, but we're going to be focusing on your ERISA fiduciary duties. If you're a governmental or a church employer, you're not subject to ERISA, you don't have those duties. So the way that I interpret this, at least at this point, is whatever you get from the settlement fund, you as the employer are allowed to keep and do with what you want. You have no ERISA fiduciary duties with respect to the settlement funds. Quickly, before we get into the ERISA duties and the claims in more detail, let's talk about the claim process. There's going to be a fairness hearing on the settlement fund. Dick, I don't know if you want to talk about. I mean, I understand that this settlement is actually the amount, while it seems big, it seems to be in line with the allegations. Do you have any prediction of whether this will be approved or?
I don't have a prediction, but all information that we have suggests that we will get an approved settlement. What I would simply say is keep your eye on the deadlines, all of which you can find at the claim administrator's website, BCBSsettlement.com, which is also on your screen in the PowerPoint. You need to submit your claim, if you choose to do so, by November 5, 2021. You can do so right through the web portal that has been set up to receive claims. You can also print out the claim forms and do so by mail. We have a question that someone had asked, what should I do if I did not keep the postcard that was sent regarding the claim? Well, you're not out of luck. If you work your way through to the FAQs in the BCBSsettlement.com web portal, there is a frequently asked question, number 19, that deals with just that question. The short answer is you are still able to identify your claim if you have one and submit it online. You do not need that postcard in order to submit the claim. The other deadline you need to keep in mind, if you want to opt out of this class action settlement, you need to do so by July 28th. And again, the claim administrator's website will walk you through exactly how to do that. Know, though, that if you do nothing, you will be included in this settlement and barred from bringing any claim and receive nothing. So you have to act if you have an interest in participating in a recovery here.
Yep. I actually, for myself, I was enrolled in an individual policy through the Blues when I was in law school, and I got the postcard. Going back to the postcard question, the postcard really didn't help me with the process at all. I logged on, did it through the website. It actually took me maybe about 3 minutes. It's going to ask you some information, but again, it goes back several years. And so when you're entering in information, it does basically ask you to make your best guess. Now, especially for you, if you're enrolled in the fully insured plan, the Blues arguably has a lot of that information. So it's just trying to identify who you are. So again, I don't think the postcard is that important. Dick, one other question I had for you, because I know that we've had a number of employers get contacted or receive solicitations from not the settlement fund itself or the administrator of the settlement fund, but third-party organizations saying, hey, do you know about this? And we can help you. What are your thoughts on that?
Yeah, thanks, Tripp. So there are organizations out there that actually pay very close attention to class action settlements throughout the country and will offer to help potential class participants in submitting claims. My counsel to my clients is that using those organizations typically isn't necessary. And you will see when you work your way through the claim administrator's website, the claim submission process is very user-friendly. It's designed so that you should not need counsel to actually submit a claim. And the reason for that is because the class itself is already represented by counsel who's taking a fee for the recovery here. And so the theory is that you would not need to pay twice. Your recovery is already going to be discounted by the attorney fee. If you choose to opt into this settlement, you are essentially hiring claim counsel and they become your lawyer here. So my counsel to my clients is you are better off in attempting to do this yourself. And if you have questions, I would contact your own attorneys to get counsel on how to submit the claim. Most of these third-party vendors will take usually some kind of a contingent fee. So class counsel is already taking a fee off the top of this settlement. If you submit a claim through one of these third-party vendors, they will take a fee on top of that. Probably not necessary. You're better off trying on your own. But if you hit a roadblock, I would reach out to your own lawyers and they can usually answer most questions for you.
Perfect. I'm going to answer one more question because we've got a number in here, but I want to keep moving on so we don't run out of time. One question asked me to clarify the amount of money in the self-funded bucket. It's 120 million, not billion. 120 million is allocated to the self-funded bucket. So, if you're a self-funded employer and you're going to participate in this and file a claim, it is likely to be that your claim is going to be smaller than if, for example, you were a fully insured. But again, the size of your group is gonna matter as well. So the settlement fund is going to be allocated between employers and employees based on the premiums or the administrative fees. Of course, the premiums are what apply to the fully insured plan. And the administrative fees are what apply to self-funded plans. And eligible claimants, both employers and employees, may select either a default option or an alternative option when they file a claim. Under the default option, if you're a fully insured health plan, there's just going to be an assumption, and the assumption is that if you were enrolled in single coverage, that 85% of the premium was paid by the employer, and that 15% of the premium was paid by the employee, and therefore 85% of the settlement proceeds allocable to single coverage would go to the employer, 15 would go to the employee. If you're enrolled in family coverage, then the default percentage switches to 66% and 34%. Moving over to the self-funded side, again, now we're not talking premium dollars here. We're talking about admin fees that the employer paid to the Blues to administer its self-funded plan. These percentages are 82% to the employer for single coverage, with the remaining 18% to the employee coverage. And then family coverage is 75%, 25%. Again, these are default options. Under the alternative option, you as either an employer or an employee, if you're filing a claim, can basically, if you have evidence or substantiation to say, I paid more likely more than what the percentage was of the default, you can file under the alternative option. And that's essentially trying to show that you paid more than what the default percentage is and maybe get a higher percentage of the settlement proceeds back, whether you're the employer or the employee. Of course, under the default option, it appears that the only thing you're going to have to file is the claim form, because the Blues are going to have the rest of the information they need to process that. Under the alternative option, you're going to have to likely submit additional documentation. What exactly that additional documentation entails is unclear at this point. And the way that the settlement, I guess, is going to be further allocated is if you're, for example, a fully insured plan and you file a claim on behalf of yourself as the employer, your portion of the settlement fund is going to be your percentage, your claim dollar amount as a percentage to the total claim dollar amounts filed for all fully insured plans. That's kind of your percentage of the proceeds, which is going to come back to you. So, I did get one initial question before the webinar: is any idea what the settlement proceeds are going to be? And there's no way to predict that, because it's totally dependent on how many people participate in this settlement fund. So let's take maybe before we shift into the plan asset portion of the conversation, you want to look through a couple of questions here, Dick, and see. I can go through a couple, but I think there's some for you.
Sure.
First, can an employee and a spouse who are both enrolled during a time period both apply for the settlement, or just one? If the employee and spouse were enrolled in different Blue Cross Blue Shield plans, or each enrolled, from a Blue Cross Blue Shield plan from their employer, you can each file a claim. But if you are the employee that's enrolled in your employer's Blue Cross Blue Shield plan and you covering your spouse under that, that's one claim. And also, since I probably got a number of people wondering this, and I did get this earlier, Blue Cross Blue Shield of Michigan is one of the licensees that's included in the settlement. And for other Blue Cross Blue Shield licensees, it's a ton of them. It's probably most of them. I'm not sure that it's all, but you can go to that website and search that to see which licensees are included. If your employer applies for the settlement, can the employees also apply? The answer is absolutely yes. And I would, I would encourage you, to my knowledge, there's no obligation for an employer to notify employees that they should go apply for the settlement. But when we get in the plan asset portion, which we're going to move to here, there may be some reasons why employers would want to encourage employees to go file their individual claims on their own. Here's two questions, I think, for you, Dick. Is there any reason an individual or company would not file a claim?
Well, there'd be only two. Number one, you have done or have the ability to do some sort of cost benefit analysis, and you've made a determination that the time that you would devote to filing a claim is not worth any potential recovery.
Which is a tough sell, because you could at least just do the default option, which probably doesn't take that long.
Correct. And then the other reason, which is more important, is in consultation with your attorneys, you've decided you want to bring this claim in your own name and not as part of the class, in which case you would opt out of the class action by the July 28 deadline and pursue the claim directly yourself.
And that actually you answered two questions there with one, because someone asked what does it mean to opt out? One more question before we try to move on. How do you know if you have a claim? Again, you may be getting a postcard. Otherwise, if you were covered by a Blue Cross Blue Shield, I would go look on that website. It also gives you contact information to call the settlement claim fund and try to, if you knew you were covered by a plan that was administered by something with Blue Cross Blue Shield in its name, try to get as much paperwork as you have and give the claim settlement fund a call and try to determine that. Okay, moving on. So plan assets. So in certain circumstances, if an employer participates in the settlement, it may receive plan assets. And that basically what I mean by that is a portion of the settlement proceeds that may be attributable to or allocable to its employees because they shared and paid a portion of the premium. So how could that happen? One way is if the employer, but not an employee, submits a claim to the settlement fund. The FAQs on the settlement fund has said in that situation, the amounts that would go to the employee are going to revert back to the employer. I think the other way that this could happen, and this is by no means the only two ways this could happen, but the other way is, for example, if the employer and employees both submit their claims using the default option, but the default option underestimated the amount that was paid by the employee, then the employer is likely going to get money that is quote unquote attributable to its employees. So what are your fiduciary duties under ERISA, at least with respect to plan assets? And, the very basic rule is that, first of all, we don't normally deal with plan assets on the health and welfare side like we do on the retirement side, because either you're remitting premiums right to an insurance company if you're fully insured, or if you're self-funded, you're keeping, those assets are held in your general assets as the employer, and there's some exemptions that the DOL has said those aren't treated to be plan assets. But when you get these settlement funds back there, to the extent that they are attributable to an employee, they appear to be plan assets, and ERISA requires plan assets to be used for the exclusive benefit of participants in the plan and their beneficiaries, or to defray reasonable administrative costs. And the Department of Labor has issued no guidance on this particular settlement fund and what employers should do. But I think what we've relied on here in the benefits group here at Miller Johnson is the most analogous situation, which if you're a fully insured, or if you're an employer with a fully insured plan out there, you may be familiar with this, is the medical loss ratio rebates that are required under the ACA. I think it was back in 2013 or 14, the Department of Labor published, some guidance on this that says, listen, portion of that rebate may be attributable to participants and therefore a plan asset, and you got to use that according to your ERISA fiduciary duties. So using that MLR rebate as kind of our launching off pad, what did that guidance say? And it really, I'm going to simplify this a lot, but it really divided the steps, your requirements into two steps. And the first one, of course, is to determine which portion of the MLR rebate is considered to be a plan asset. There's not really a precise calculation for that, but they say to use the ordinary notions of property rights. So a common method that seems to be okay with the DOL is kind of a pro rata method. So for example, if an employer paid 80% of the premium and the employee paid 20% of the premium, the portion of the MLR rebate that belonged to the employee and therefore was a plan asset was 20%. Self-funded plans out there, you're not familiar with the MLR rebate, maybe you've heard about it, but you're not eligible for it. But if you're here in Michigan and we're with Blue Cross Blue Shield, probably the closest analogy, and maybe you've been through this before, is if you participated in the hidden fees settlement. Generally for our clients that got some settlement money from Blue Cross Blue Shield of Michigan due to the hidden fees litigation, we said again, using this MLR rebate guidance, you may have to share a portion of those settlement proceeds with your employee. So first, step one is to determine the portion of the MLR rebate that's a plan asset. The portion that's not, that belongs to the employer, you can use as an employer, you can use it for whatever you want. There's no fiduciary duties that go along with that. Step two is determine how to use the portion of the MLR rebate that is a plan asset in a way that's exclusively for the benefit of plan participants and their beneficiaries. The permissible options, and I think the most common options, are one, providing a taxable, compensation. You increase the pay. You say, okay, here's the portion that's the employees. I'm going to, that's a plan asset. I'm going to divide it up between employees, maybe evenly for all employees. Or maybe if my folks who are in family coverage paid a little bit more, they get a little bit higher, but we give them basically a taxable bonus. The other thing is, as a premium holidays, is, if they're continuing to participate in the health plan, maybe we waive, their premium requirements or reduce them for a period of time. Now, really, that's not all that different from a taxable refund, because if I lower the amount of your pre-tax withholding, that's going to increase your taxable take-home pay. The other third option is enhancing plan benefits. I didn't see this used much. Adding certain benefits on, again, enhancing benefits. I don't see this as much in the MLR rebate world, only because usually the rebates are not that big, and it would be difficult to do. The one thing to note is that the DOL guidance says, at least with MLR rebates, and this goes back to some old DOL non-enforcement rules, it says, once you get that MLR rebate, whatever you decide, however you decide you use the plan asset portion for the benefit of participants, you got to use it within 3 months. So, if it's large enough and you're trying to give premium holidays and you're not going to use the whole plan asset portion within 3 months, you may have to do the taxable bonus or taxable refund through compensation to your employees. Next one's going to be a big issue for employers here, and that's what to do with former participants. Again, going back to that MLR rebate guidance, and let me take a step back, I apologize. And obviously the settlement class for fully insured plans extends back to 2008. It's back to 2015 for self-funded plans. So you're going to get money for not only, people that maybe are still in your employ, but aren't participants in your health plan anymore, but more likely people that have left your employment and maybe have left your employment a number of years ago. Do you have to share it with them? The general answer is maybe. And the MLR rebate guidance says, well, you do at least have to factor them into the calculation. But if you made a reasonable good faith effort to determine that, hey, the cost of me locating these people, sending them a check, and then if I trigger, W-2 withholding requirements, preparing a W-2 on them, if all of that cost is going to exceed what they're going to even get, then you can kind of exclude the former participants from the calculation or from the allocation, and you can take their portion, move it back in, and distribute it to current participants. And most of the time, that's what I see with MLR rebates, again, because they're quite small. Whether that's going to apply here for this Blue Cross Blue Shield settlement depends. And it's hard to say at this point, because I think it's going to depend first how much you're going to get back out of the settlement or what your settlement proceeds are going to be like. And then are you going to be able to ascertain what are the plan asset portion and what that amount is? If it's fairly small or negligible, you're probably going to be able to disregard former participants. But if it's real big, you may have an obligation to consider or try to allocate it to former participants to the extent that you can find them. Kind of rounding this out, we got a few questions that at least I've thought about, and then we'll spend here a few more minutes we've got a number of questions in the chat feature that we'll try to get to a number of those. But I guess the first question that I have is, does an employer have a fiduciary duty under ERISA to submit a claim to the settlement fund? And that goes back to the question we have, why wouldn't you want to do it? Maybe one reason you do is if you do have a fiduciary duty under ERISA to actually go after this money, knowing that some belongs to participants, maybe there's some obligation there. Now, the big difference between the MLR rebate and this settlement proceed is the MLR rebates are all sent right to the employer. The individual has no ability to go in and get it himself. Here in the settlement fund, the individual does. So maybe the fact that the individual can go actually participate in the settlement proceeds themselves on an individual basis, maybe that relieves the employer if they say, I don't really want to deal with this. I guess, and that would kind of lead me to the second question. Since individuals can submit individual claim, does that relieve the employer of their fiduciary duties with respect to its settlement proceeds? Meaning, hey, what I get, I always like to say, my high school Spanish teacher always used to say, Dick, I can lead you to the water, but I can't make you drink, right? So my employees had a chance to go get this. If they didn't do it, too bad, so sad, and I got a portion of it, that's it. I don't know. If that's, I would say that's a more risk tolerant or risk-seeking approach. The more conservative approach would say, well, if I get the settlement, I should at least do my best efforts to determine what are plan assets and to use those accordingly. I guess the other thing is we don't know what information we're going to get back with the settlement proceeds. Like how much, which employees, how many employees did submit a claim, or how many did that we thought that didn't. Are we going to be able to even make this, a reasonable determination, or are we just going to get a check and nothing more? I don't know the answer to that question. And if you don't, and so if you don't have it, how do you do this? We are working. I'm working with some other attorneys in here to try to get the DOL to issue some guidance on this. I'm not terribly optimistic. They are obviously really busy going through issuing guidance with, under the Consolidated Appropriations Act and the American Rescue Plan Act. And I think normally they wouldn't weigh in on an individual settlement. My only source of optimism here is this settlement is huge. Again, $2.67 billion. It's going to affect thousands, if not millions of employers, indefinitely millions of individuals. So it seems like it might be a big enough deal that they may want to weigh in. So with that, I think maybe you want to spend a couple minutes trying to get through these questions, Dick?
Absolutely.
Let's, I think the first one, it says that this will likely become, so do employers have an obligation to file if we are automatically considered to be a part of the settlement? Well, you have to file to actually participate in the settlement, whether you're an employer or an individual. Whether you have an obligation to do that under ERISA, I think is unclear. But you're not, if you don't file a claim, you're not getting any money, and you're also going to be barred from filing future litigation against Blue Cross Blue Shield, at least on the same basis. As an employer, are we required to notify, educate our employees on the class action? Again, I don't know of any ERISA or other reasons why you'd have to do that. But again, if you think about it, if you want to minimize the amount of employee money that you may get as an employer, it may be in your best interest to notify your employees, or at least let them know that they can go out there and participate in the settlement.
And that's a fairly common question. Common enough that the FAQs and the web portal, I think, have answered that. If you go to question number 37, the short answer is no. The employees should be receiving their own notice. There is a phone number to call. Nothing prevents you as just kind of a general service to your employees from maybe posting something or sending an email out with the phone number or the contact information. But you as an employer do not have that obligation.
And I do want to point out, if you start perusing the FAQs on there do state that you as an employer are not, I believe they state that you're not required to share your settlement with employees. They didn't necessarily think about that from an ERISA standpoint, right? These were not ERISA lawyers that filed this lawsuit. So I know that statement is out there. And if you want to rely on that, I think beware. I don't think I would rely on that statement. And of course, they're not providing you legal advice anywhere. So if they turn out to be wrong, it's still going to all be on you. Great question I got. If the employer paid the full premiums, what amount would fully go to the employer then? Well, I think if you paid the full premium for the entire class period, then any settlement proceeds that you get belong to you as the employer. You don't have to go through this plan asset analysis, and you get to keep. Now, one thing I will point out is you're going to want to make sure that you file under the alternative method. Otherwise, you're going to get the default percentages. And theoretically, if you file under the alternative method and that's accepted, and you have any employees that try to file an individual claim, that claim will be denied because you will have shown that they didn't pay any portion of the premium. Is the process for the employer to file the claim the same or different for employee? What information, if any, does the employer need to file? So I think the claim form either on the website appears to be the same. And I guess I don't know. I went through the individual, but you go to the website and it says, are you an employer? Are you an individual? And then I think it further says, if you're an individual, you enroll through an employer plan or an individual plan or both. So I went through the individual because I didn't file on behalf of an employer. I did myself. You go through the website, but there's probably going to be, different requirements, whether you're an employer or an individual. Again, for an individual, I did mine in about 2.5, 3 minutes. It was pretty easy. You have to sign a statement that you're not lying. But again, it also says to try to, put some of this information into the best of your recollection, knowing that, if you're in a fully insured plan, it goes back to, 13 years ago. If you received a postcard personally, but you were on an employer plan, will you get a refund if your employer files, or do you need to file your own claim? Again, I would recommend filing your own claim. If you are participating in your employer's plan, you paid a portion of the premium, your employer may share that premium with you because they're required to under their ERISA fiduciary duties. But if they're not on this webinar and they don't know about that, they could easily keep that entire refund themselves, especially if they're just relying on the FAQs on the claim administrator's website that says you don't need to share it with your employees. So if you are an individual participating in an employer's plan, I recommend that you file your individual claim. Okay. If we know the employer paid 75% of the premium for single coverage, can we still use the default method, or is this fraudulent? Oh, that's a good question. Again, I didn't go through the claim. You're signing that says that you're submitting a claim to the best of your ability, and that recommendation, if the default percentage is higher than what you paid as an employer, my recommendation would you file through the alternative percentage or the alternative option, and to state that you paid a lower percentage. I'm not so sure if it would rise to the level of being fraudulent, but I wouldn't even go down that road. Is Blue Cross Blue Shield of Illinois as part of the settlement? Dick just checked that. The answer is yes. I figured that was the case. If an employer submits evidence of employer contributions, does it apply to all employees? My guess is going to be no. That they will not. If I let's just say I, as an employee, said I paid more than the default percentage and I've got enough information to prove that, I file it in. I do not believe that the settlement fund is going to take that and say anybody that files on behalf of this employer is going to get that same thing. In fact, some of the employees may say, I'm just filing under the default option. And I think that for the settlement fund purpose, the administration, the buck stops there, right? They're going, well, default fund, boom, we're done. What should an employee do if they filed a claim and selected the incorrect plan, Blue Cross Blue Shield of Michigan versus Blue Cross Blue Shield of or BCN? If they selected the wrong plan, I think this will be identified because the claims administrator is going to work with Blue Cross Blue Shield of Michigan or BCN, which is basically one and of the same, and the request information back. Again, they're going to use the information that you submit to basically try to identify you. And then as far as the premium that was paid, whether it be an individual premium or an employer premium, they're going to take that premium amount information that they get from the Blues, and then they're going to either apply the default percentage or alternative option percentage based on how the claim was filed.
And you can also email the claims administrator or phone the claim administrator. Both of those contacts are in the settlement website.
If not selecting the default, are contributions based on the aggregate average, or will they differ by class plan down to the individual? That's a tough one to answer. I would say in the perfect world, in the easy world, if you just said I pay 20% of individuals, 30% of family coverage, then that's what it is. But I know that some employers, the more sophisticated ones out there, may have blended percentages. They may pay, they may say, I pay this much of percentage, and I carry for an individual, I kind of carry that across the board. So it's 20% across the board. This is going to be tough. I don't know the answer to that question. And I think it's going to be, up to you and the claims administrator to prove as precisely as possible what percentage you pay. We'll keep going here for about 5 more minutes. I'm just going to warn you folks, though, we've got over 20 questions still to go. We are not going to get to all of them. I apologize for that. If an employer doesn't file a claim, can the employee still file? Yes. The employer and the employee's claim are no way tied to each other. So if one files, the other one is not required or barred from filing. Now, keep in mind, one thing I will point out, if an employer files a claim and an employee doesn't, the employer is going to end up with that money. with the amount that was allocable to the employee, if you will. If the employee files the claim, but the employer doesn't, the employee is not going to get the amount that was allocable to the employer. So it's not a two-way street, at least with that regard. For self-funded plans, you indicated under the default option, the employer-employee percentages were based on the Blue Cross Blue Shield administration fee. Does that include stop-loss fee if stop-loss coverage is purchased through Blue Cross Blue Shield? I don't know the answer to the question. My suspicion would be no, though. Only based on the litigation had to do more with the Blues basically saying, I won't go into a different Blues backyard and try to compete with them. And I don't really see how that would involve stop loss too much. So I could be wrong on that, but I'm not sure. And I realize that that's unfortunate because the stop loss is probably a huge part of your fees to the Blues. Do employers get a notice on this, like cards that went out to employees? I don't know. I haven't had any of my employers that are the Blues let me know. I think employers are largely aware of this, to be honest with you. So I'm not so sure that they need. This is becoming pretty publicized. So, and I think we'll even become even more publicized as we get closer to the claims filing deadline. Do you expect the settlement will have detail to know how much was based on employees not submitting a claim? I wish I could tell you that. I don't know. And if you don't, I don't know how you make any type of reasonable calculation to determine plan assets, which is again why I'm hoping maybe the DOL will issue at least some informal guidance on this or opine. What should I do if my parents were covered by Blue Cross Blue Shield of a school program, but they are now deceased? Was that addressed in the FAQs? I'm going to let Dick look at that and move on here a sec. If the employee portion of the premiums is pre-tax, the amount is refunded would be taxable, not considered pre-tax. Yeah, so if you give the employee portion back, it's a taxable refund to them. It would not be pre-tax.
And the answer, yes, a claim can be filed on behalf of a deceased. There's some direction on how to do that in the web portal. Go to FAQ number 46.
Perfect. Any guidance on what constitutes a de minimis amount that may negate the need to distribute funds to employers? That's a facts and circumstances question. So it's only it's going to be the amount that you get, the amount attributable to your participants that you can determine, and then I think largely dependent on your size, right? The larger you get, maybe and there's technically no de minimis amount, but I think it falls within this kind of reasonableness that it seems ridiculous if you're going to start passing out cents, right, to employees. And of course, if you always want to be conservative, maybe you throw some of that money at a benefit enhancement. You add some type of wellness perk or something like that. Will the settlement to the employer list the employees are included? I don't know. If the employee makes their own claim, will the funds give the employer reduced by the amount paid to the employee? Yes, if an employee makes their own claim, then that will be offset by the amount that goes to the employer. But whether you know which employees made a claim as an employer, I have no idea if the settlement's going to share that information with you or if you're going to be able to get that. Seems like ERISA duty of prudence may encourage employer to file a claim regardless of what the participant is doing. I agree with that with one caveat. If you, and this would be almost ridiculous, but if you were an employer and you paid 100% of all the premiums on behalf of your employees for the whole settlement period, and you said, I just don't want to do it, I think you'd be okay. I don't think, because arguably nothing would belong to the participant. And frankly, if you had a couple of them file a claim just for fun, they would end up getting a portion of the settlement that didn't actually belong to them. How would an employer know if an employee already received a rebate in order to leave that employee out of the calculation? I don't know. In fact, you may not know, and there may be some employees that file their own claim, and if and may get a distribution from their employer as well. There may be a windfall employee. But it seems unfair, but I think at this point, the employer's concern is to comply with their ERISA fiduciary duties so that the Department of Labor doesn't show up and say, oh, you got this huge settlement and employees pay 30% of the premium. How much of the settlement did you share with them? So again, I think maybe we'll host another one of these webinars after the later this fall or winter when we know more what information we'll get after claims are submitted. There's a lot we don't know at this point. Okay, one more question. I think we're going to have to call it good for the day. If you are an employer, ERISA exempt employer, are you required to share your refund with employees? So probably this individual represents a government that's not excluded from the settlement fund or a church, and the answer is no. You certainly have no ERISA fiduciary duties. I'm in Michigan, not aware of any state law requirement that would require you to share it. Potentially, if you're in a different state, you may want to check that. But I would say if you're exempt from ERISA, have fun with the full settlement that you get, and think of your friends over at ERISA subject employers that have to go through this calculation. With that, I'd like to thank everybody for joining us today. Again, I apologize we couldn't get to everybody's questions. But again, we will be monitoring this. We will continue to issue client alerts as we see developments that we think people should be aware of. And quite possibly, if we learn some more pertinent information, we will try to host another webinar. With that, we hope everybody has a great rest of the day and a great weekend. Thanks again for joining. And thanks, Dick.
Thank you, everyone.